This Swanson Reed presentation seeks to inform interested parties regarding a potential compliance risk arising from the inappropriate use of artificial intelligence, also known as AI, to draft companies' descriptions of activities for applications made under the Research Development Tax Incentive, or RDTI. Over recent months, there have been media reports highlighting inappropriate or over-reliance on the use of AI in other sectors, such as those providing consulting services to the government or by entities involved in legal proceedings presenting evidence in court. We have identified a potential future risk that the Australian government dual regulators who administer the R&D tax incentive, the DISR, and the Australian Tax Office, that they could potentially and rightly become concerned if AI was being used to prepare and lodge inaccurate R&D tax claims. While AI offers incredible potential for efficiency and there has been a global rise in businesses leveraging it in their day-to-day operations to streamline various tasks, companies should be cautious with its use when it comes to the preparation and review of formally legally binding documents submitted to federal government agencies, such as an R&D application. This session seeks to outline the core risks and remind applicants of their formal obligations and provide some recommendations for managing these risks. The context in this presentation is general information only and should not be taken as dedicated tax advice. In recent months, we have observed a growing trend in which companies may be using AI to assist with the collation of initial draft content for their research development tax incentive applications. The regulators are likely noticing this trend as well, and we anticipate that they may adapt their processes to target compliance in this area. Swanson Reed acknowledges that AI is not without value in the R&D claim process. It can enhance efficiency in certain preliminary stages of R&D, such as assisting with documentation by compiling literature reviews at the outset of the activities to assist with assessing the current state of knowledge, or that it may be useful in some areas collating text for application if used with a careful human review. But we urge that applicants take a disciplined approach and maintain a clear boundary between the critical compliance steps and the high-level technical substantiation required by the law. When companies lodge an R&D application with the AusIndustry, they must provide quite a lot of text-based information about their company and their R&D activities. This information includes, but is not limited to, an overview of the company itself and its reasons for undertaking a project, an overview of the R&D production, a detailed description of each core R&D activity within the project, including its hypothesis, details of the knowledge sought, details of the process for assessing whether the knowledge was known and if the outcomes were able to be determined in advance, details of the testing process and evaluations, details of the conclusions and status at year-end, a description of supporting R&D activities undertaken, including a detailed description of the relationship between the activities, and other company details around the facilities, record keeping, and financial disclosures. R&D applications can be many tens or even hundreds of pages containing a lot of text. For this reason, some parties may seek to use AI for collating details to be populated in the R&D application. However, it is very important that companies and advisors are aware that an R&D application is a statutory document lodged with a federal government agency, whereby a company must provide a factual account about activities that have or are in the process of being undertaken. An R&D application is not a prospective grant application, nor can it be a fictional account of activities that may or may not have been undertaken. The R&D application process demands a factual, evidence-based account of R&D activities that have genuinely been undertaken by the company. The application contains specific declarations that the R&D entity is required to acknowledge. These declarations are important to the integrity of the R&D TI program and can be used as legal evidence as they must be factually accurate. Companies that are lodging an R&D application should familiarize themselves with the declaration they agree to within a submitted R&D application, which currently are: I, as the declarant, have authorization to represent, act on behalf of, and bind the company, including to lodge this application. All contact persons specified in this form have the necessary authority to represent and act on behalf of the company in relation to the R&D tax incentive. I consent to my personal information, and I have obtained the consent of all individuals whose personal information is in this form to their personal information being used for the specified purposes of this form, I will provide each individual with a copy of the privacy statement. To the best of my knowledge and belief, the information in this application is true and correct in all material details, and that the activities and corresponding expenditure described in this application meet all prescribed eligibility requirements for the R&D Tax Incentive Program. I understand that giving false or misleading information is a serious offence. The R&D entity, while undertaking the activities described in this application, has maintained records while the activities were conducted, substantiate the conduct of the activities to be registered for the R&D tax incentive, and that the R&D entity will provide information as requested by the Department of Innovation Science Australia to support the application for registration in the future, and that the company will do so in a reasonable amount of time after receiving a request. Furthermore, the declarant acknowledges that they have read the assessment tool on AusIndustry's website and that they are aware of the risks and guidance documents flagged within the website and the application. When submitting the R&D application, transparency is vital. The R&D entity is required to formally acknowledge several critical declarations, including that the information in this application is true and correct and accurate in all material details, and that the activities and corresponding expenditure described in the application meets all prescribed eligibility requirements for the R&D tax incentive. The entity must also acknowledge that giving false or misleading information is a serious offence. The R&D entity, while undertaking the activities described in this application, has maintained all records while the activities were conducted to substantiate the conduct of the activities to be registered for the R&D tax incentive, and that the R&D entity will provide further information as requested by the Department of Innovation Science to Australia to support the registration in the future, and that the R&D entity will do so in a reasonable amount of time after receiving a request. Any deviation from a strictly factual description represents a fundamental compliance failure, and that this risk is significantly amplified when using AI assisting drafting. Applicants must remember that in the eyes of the regulator, an automated inaccuracy is still an inaccuracy, and the consequences for claimant remain just the same and as severe. When submitting the R&D application, the R&D entity is also required to make specific declarations regarding the evidence kept in relation to each R&D activity. This includes evidence of the company's hypothesis and the experimental setup, evidence of investigations and research made to find current knowledge, an explanation or evidence of why the outcome could be known or determined in advance. The primary risk when integrating AI into the R&D claim process is the inherent risk of the technology generating content that is false, exaggerated, or inaccurate. This can be referred to as an AI hallucination, in which the software produces information which may be a deviation from the actual R&D activities undertaken. This could lead to the generation of descriptions that are exaggerated, technically inaccurate, or lacking alignment with internal evidence and the physical reality of the R&D, which makes the entire claim vulnerable under audit. To manage the risk, Swanson Reed strongly advises all companies using AI to assist with their drafting process that they undergo a thorough human review of their final submission. Key groups conducting this final review should ideally include an experienced R&D tax advisor. This should seek to ensure that the technical descriptions are prepared in alignment with the R&D tax legislation and current compliance trends. This should also include personnel directly involved with the conduct of the R&D activities. This would seek to ensure that the activities descriptions are factually correct and consistent with any evidence that is available and which may be called upon to support their claim. This should also include personnel responsible for company governance. This may or may not be the same person conducting the activities. However, R&D applications should be reviewed by those responsible for managing tax governance with a company, such as a director or key finance personnel, to confirm that information disclosed to the government agency is factual and appropriate. This multi-step human verification process provides the necessary safeguards against factual errors or AI-induced exaggeration. To conclude, while AI is a powerful tool for efficiency, it should be treated with caution when preparing R&D applications, and subject to a thorough human review prior to submission. We anticipate that the regulators may review R&D applications identified as likely to have been drafted using AI particularly closely, and that this may become a compliance focus for regulators in the year ahead. At Swanson Reed, we work closely with companies to review applications and confirm that activity descriptions are correct and align with contemporaneous records. If you require assistance and would like to speak to someone about a potential claim or check the compliance readiness of your next submission, please contact our office. Thank you.